In the Supreme Court, the case of Georgia versus Brailsford. Bill in equity. This case was again brought before the court upon a motion by Randolph to dissolve the injunction which had been issued and to dismiss the bill. He assigned two grounds in support of his motion: that the state of Georgia had no remedy at law to recover the debt in question, and second, that even if there was a remedy at law, there was no equitable right to justify the present form of proceeding. The motion was opposed by Ingersoll and Dallas, and after argument, the opinions of the judges, in the absence of Justice Johnson, were delivered as follows. Justice Iredell: It is my misfortune to dissent from the opinion entertained by the rest of the court upon the present occasion, but I am bound to decide according to the dictates of my own judgment. The state of Georgia complains that having a right to the debt in question, that right has been discussed and overruled without giving her an opportunity to be heard in support of it, though. That right has been discussed and overruled without giving her an opportunity to be heard in support of it, though she applied to the circuit court for the purpose. It is another grievance alleged that a writ of error has not been instituted when, all of the facts appearing upon the record, the decision of the circuit court might have undergone a full and satisfactory revision before the tribunal of the last resort. As a writ of error could not be sued out without entering security, the state, to entice herself to any benefit from the exception, ought, in strictness, to have tendered a security in the defendant in the inferior court. But still, if a writ of error has been brought, it appears to me that it could only affect the original plaintiffs and defendants in the suit, and the state of Georgia cannot be made a party to the record. In this situation, it must likewise be considered Georgia had not a constitutional right to initiate a suit, nor could she, in my opinion, be admitted as a party to a proceeding in the nature of an interpleader in any but the Supreme Court. The state, however, asserts a claim to the debt in controversy by virtue of an act of confiscation, and the debtor admits that he ought to pay the amount of his bond, but is doubtful to which of the contending parties it ought to be paid. Now, without the equitable interposition of the court, I think there will be a defect of justice, for it is obvious to me either that the state can have no remedy at law, or at least that the remedy at law will not be plain, adequate, and complete. Two positions have been taken in opposition to this opinion: that if the state is entitled to the debt, she may maintain an action on the bond against the obligors, or second, that the state might bring an action of assumpsit for money had and received, and against Brailsford if Brailsford had no right to recover or retain it. I will carefully consider both these positions. First, in the first place, it is to be recollected that the bond is merged in the judgment, and although the judgment is said to be generally binding only on the parties, yet it is good against all the world until it is reversed in a regular course of law. To any other suit for the same cause, Spaulding might plead the previous judgment in bar, and the plea could only be defeated by shewing fraud or collusion. There is no pretense, however, for an imputation of that kind here, since Spaulding set forth the title of Georgia as fully as the state herself could have done, and would it not be monstrous, after a judgment rendered under such circumstances, to compel him again to pay the same debt? There is neither principle nor precedent for so hard and oppressive a doctrine. But if a suit could be maintained upon the bond by the state, how is she to obtain perfection of the instrument without the aid of a court of equity? Suppose it has been deposited with the clerk of the circuit court. That officer cannot deliver it to the state without the judicial mandate of a superior tribunal. Suppose it remains in the hands of Brailsford. He can hardly be expected voluntarily to furnish his antagonist with the means of combat, In short, it is only by the authority of this court, sitting as a court of equity, either that the separation of judgment obtained at common law against Spaulding can be prevented from becoming conclusive on the question of right, or that the state of Georgia can be enabled to maintain her claim upon its merits. Second, it is urged, however, that the state has another remedy at law, by an action of assumpsit for money had and received against Brailsford. This is indeed the legal Panera of modern times, and may, perhaps, be beneficially applied to a great variety of cases. But it cannot be pretended that this form of action will lie before the defendant has actually received the money which the plaintiff demands. In the present instance, the money has not been received by Brailsford, and of course he cannot be compelled to account for it to Georgia. The case of Moses v. McFarlane, if at all applicable to the points now in controversy, will be found more favorable, I think, to the opinion which I entertain than to the opinion which it has been cited to support. From that case, which presents most unconscionable conduct on the part of the defendant, it is to be inferred, as I have already stated, that a judgment is a perpetual bar against a second recovery for the same cause, unless it is tainted with fraud and collusion. But the King's Bench proceed in deciding the question before them on this ground, principally, that the inferior court, the court of confeasance, could not take cognizance of the collateral matter, which constituted the defense, whereas, in the present instance, the matter pleaded by Spaulding was perfectly within the cognizance and jurisdiction of the Circuit Court. From this view of the subject, therefore, I am indeed to conclude that the state of Georgia has no remedy at law, and it is sufficient for an incipient exercise of the jurisdiction of this court, that she has shewn a color of title to recover the money, and that the money is in danger of being paid to another claimer. I abstain from giving any opinion upon the judgment of the Circuit Court, but certainly I should never have consented to issue an injunction if I had thought the legal remedy of the state was plain, adequate, and complete. If the bill is sustained, the money will be perceived in neutral hands, and the court may direct an issue to be tried at the bar in order to ascertain whether the state of Georgia or Brailsford is the rightful owner. Justice Blair. My sentiments have coincided, till this moment, with the sentiments entertained by the majority of the court. But a doubt has just occurred, which I think it my duty to declare. I do not conceive, indeed, that any judgment can be binding upon the rights and interests of a third person who is not a party to the suit. The very nature of a bill of interpleader presupposes that the party by whom it is exhibited would be liable a second time if he should enter voluntarily or otherwise pay the money which he owes to a wrong claimant. A judgment would not, therefore, in such a case, be a bar to the action of the claimant, who was legally entitled and who might either bring either detenue or trover for the bond against the possessor of it, or if he instituted an action of debt against the obligor, the court might, on a proper hearing, order the instrument to be delivered into his hands. Presuming, then, that there was a remedy at law, I have hitherto thought that there was no ground for the interference of the court as a court of equity. But upon reflection, it appears that if Brailsford, who is a British subject, should get the money under the present judgment and leave the country, there would be great danger of a failure of justice. It was for this reason that the injunction was originally granted, and I think the reason ought to carry us till farther. Admitting that Georgia has a complete remedy at law, her right, though not supported by herself, has been stated on the Circuit Court, and though the judgment in that case is not binding upon her, yet, in any future suit brought by her against Spaulding, who is bound by the judgment, a familiar difficulty will arise, for the court would then be called upon to decide in the absence of Brailsford, who could not be a party to the common law suit, upon his claim as well as upon the claim of Georgia. Since, therefore, there is no other court that can bring all the parties before them, and do general and complete justice, it is my opinion that the bill in equity ought to be sustained, and that the subject should be no further referred to a court of law than to obtain an opinion upon the legal title to the debt in controversy. Chief Justice J. All the court, except the judges who have just delivered their sentiments, are of opinion that, if the state of Georgia has a right to the debt due originally from Spalding to Brailsford, it is a right to be pursued at common law. The bill, however, was founded in the highest equity, and the ground of equity for granting an injunction continues the same, namely, that the money ought to be kept for the party to whom it belongs. We shall, therefore, continue the injunction till the next term, when, however, if Georgia has not instituted her action at common law, it will be dissolved. It is so ordered.